Hello, good morning. This is Dr. Iftikhar Ahmed Ansari, Department of Political Science, and today I'll make my presentation on federal government. In one of my previous videos, I have already talked about what federal government is, and what are its different characteristics, how it is formed, what are the theories which are governing its formation, and what are the methods of its division or distribution of power. In my present lecture, I am going to talk about the prerequisites for a federal form of government. Now, such a system of government which is federal in nature, it demands the presence of certain conditions which should exist to pave a way for the federation to come into existence or to materialize. Now, according to Dicey, there should be in the first place a strong desire to have a union. Now, the will to have a union and to be under a single independent government for some purpose is really the basis of a federation. So, it means that the federating units, they must be inspired and bound together by a sense of oneness. Now, that comes with a desire to objectify if politically. So, unless they become a community of interest sharing each other's weal and woes, their cohesion into a new state is extremely difficult. Now, the second requisite or prerequisite for having a federation is that the condition is that the federating states must desire union rather than unity, because unity is the characteristics of unitary form, and here the union, it should be a desire on the part of the federating states for national unity and to be under a single independent government. They must desire at the same time to maintain their individuality and autonomous existence by establishing independent regional governments in some matters at least. Now, the aim of federalism is to give effect to both these sentiments. Now, it is in this context Dicey defined a federation as a political contrivance which intended to reconcile unity and power with the maintenance of state rights, or to express it in the words of Weir, the group of states or communities must desire to be united but not be unitary. Now, but this is not all. Something more is needed besides these two prerequisites, and that there should not be a desire to have a federation, but the power or ability to operate it as well as to maintain it. So, operationability and maintaining is another aspect. So, the states or the communities, the desire to have a federation, explains Weirs, must have the capacity to work the system they so desire. The federal government is not appropriate unless the communities concerned, they have the capacity as well as the desire to form an independent general government and to form independent regional governments. So, the factors which determine their desire and aspirations as well as their capacities to make them operational deals may be called a prerequisite of federal polity, and it may however be noted that it is unlikely that all these factors will be present among states desiring union, but it is necessary that most of them must be present if the federal system is to work smoothly and efficiently. Then one of the main incentives to closer association is feeling of homogeneity. Now, this is the another important prerequisite, what Mills calls mutual sympathies among the population. So, population need to have a kind of empathy for each other. So, the sympathies available for the purpose, he says, are those of the race, language, religion, and above all of political institutions as conducting most of the feeling of identity of political interest. Now, in his earlier enumeration of the factors making for nationalism, Mill included geographical unity and common memories, that is a common historical radiation. However, both should appear here. Geographical unity and common historical traditions help to create a sense of oneness even if other factors do not exist. Now, Mill observes that people may bind themselves together in resistance to oppression. So, the Swiss, they did so. They continue to cooperate in the spirit of cooperativeness in spite of the diversity of language and religion, at a time when religion was the grand source of irreconcilable political enmity throughout the Europe. So the exposed frontiers and the danger of aggression from vicarious neighbors dictate union for the purpose of defense. So greater the menace, the closer will be the union. In Canada, the desire to union arose in spite of differences of language, religion and race. And the union of South Africa occurred in spite of similar differences between the Dutch and the English who inhabited the country. Then yet another prerequisite is the presence of a leadership. It is thus must be made very clear that strong as the forces of language, race, religion, nationality might be in producing a desire for union, now such a desire cannot be materialized and come into real force unless they possess a kind of a leader and the leadership that looks for creating that union. Now, a great deal therefore depends upon the political leadership and the statesmanship at the right time. Now, this helps to combat the forces of the narrow forces of racism or fanaticism or linguistic chauvinism. Now, differences of such kind, it instills the people with a kind of disunity which are leveled or which were brought together or removed by the leaders. Now, the desire for union in Canada, we find, was made effective by the leadership of men like John Macdonald, Alexander Galt, and George Etienne. In America, the people had a community of language, race, and religion, and similarity of political institutions, but these factors had failed to produce anything beyond a confederation. So it was under the leadership of Washington, Hamilton, Madison, and Benjamin Franklin and James Wilson that delegates at the Philadelphia Convention in 1787 with a manly confidence in their country, they threw the Articles of Confederation aside and designed to bring unity into the diversity of a new nation. But this may not happen everywhere. Like in the case of India, if we talk about the leadership of Congress and Muslim League, under the inspiration of their leaders, they had all through relied upon the theory of separate country and separate nationhood for Muslims and the creation of separate homeland. And as a result, if these separate tendencies and separatist tendencies would not have been given wind by the leadership of those times, then this partition could have been avoided. But then it was the otherwise, the results would have been different, unified Indian Federation rather than a division of country into two parts, India and Pakistan. So this factor of leadership, of skill in negotiation and propaganda can make, observes Weers, all the difference between stagnation and an active desire for union. Now, yet another prerequisite for a federation is its geographical location and its contagious nature. So the areas having the desire to federate, they should be geographically contiguous. That is to say, the states desiring to federate or to be brought within the fold of a federation as a result of centrifugal forces should not be separate from one another by distant spaces of land and water. That is, they must exist in the vicinity of one another. For neighborhood makes them a community of interest, and the desire for union is inspired by the needs of common defense, common economic advantage, and similarity of institutions. Geographical contiguity also makes to produce a capacity to work as a federal union. So federal government demands of units to run their own administration as well as to participate in the federal government. So distance leads to carelessness or carelessness, says Gilchrist, on the part of both central and local governments. So national unity is difficult to attain where the people are residing too far off. So the benefits of common defense and the economic advantages from union cannot be adequately secured. One of the causes of such a federalism in America is the contiguity of all the states. So are the cantons of Switzerland and the provinces of Canada and the states of Australia. So the Indian Federation also commands contiguity of its component states, but there are no nearness of vicinity of areas between the two parts of Pakistan. The West Pakistan was separated from its eastern counterpart by a wide stretch of land, and the erstwhile East Pakistan was landlocked by Indian territory, and this separation was, among other things, inter alia, one of the causes of the secession of East Pakistan from the West Pakistan and the establishment of former of a new state of Bangladesh. So the nearness is an important factor in formation of a federation. Then another prerequisite that can be underlined is the political institution. Now, of all the factors which produce the desire for union, similarly and similarity of social institutions and particularly the political institutions is one which is very important because it produces the best of capacity for union. Now, Weir remarks that the desire for union has practically never been aroused unless similarity of political institutions was present actually or potentially among those who envisage the formation of a union. Now, similarity of institutions create conditions of common political structure, which in its turn makes possible the development of a common political culture. Now, it is essentially for this reason that the system of government established at the center finds its replica in the federating units also. So, the Constitution of United States, Switzerland are both required that their respective units must have a republican form of government. In Canada, Australia and India, the parliamentary system of government has been explicitly established in all the units. Now, yet another condition and prerequisite for having a federation is limited and free government. Now, this is one of the most important features of federalism, and the system of government which it establishes must therefore ensure free election and a party system and the existence of opposition. Now, there can be no free elections where there is autocracy and the representativeness of the government are the nominees of the autocrats in the region. So, dictatorship of one party government and it does not permit existence of opposition goes against or flies in the face of the federal form of government. So, elections are just a routine affair in such a dictatorial kind of a regime and where any kind of authoritarianism exists. So, this goes or militates against the concept of federalism. So, this is the negation of free elections and as such incompatible with the working of the federal principles. Carl Friedrich says that federalism is an integral part of the modern constitutionalism, and constitutionalism itself means the limited government. So, a federal government structure, he explains, provides a spatial or territorial as distinguished from a functional division of powers. Now, such a division operates as rather effective restraint upon the abuse of government power by the central authority. Now, yet another prerequisite is equality of status. Now, it would have been difficult to operate a union between the provinces and princely states as envisaged in the Government of India Act 1935. The proposed federation would have been a combination of strange bedfellows. So, the provinces were given under the Act of 1935 provincial autonomy with representative institutions and a responsible form of government, whereas the states were to continue under the personal rule of the princes. Now, the representatives of the Indian states in the central legislature would have been the nominee of their rulers and not elected representatives of the people of the states. So, the British government, in the words of Sir Samuel Hoare and then Secretary of State for India, had really intended to counterpoise democracy with autocracy. So, with that condition, the federalism of any kind in India would not have been possible. So, before inauguration of the new Constitution of India 1950, which declared India a union of states, all the princely states were liquidated and homogeneous political institutions established in all the component states of the union. The States Reorganization Act in 1956, it further abolished the distinction between Part A, Part B and Part C of states which the Constitution had established in 1950. So, the States Reorganization Commission aptly remarked that the one only rational approach to the problem in our opinion will be that the Indian Union should have primary constituent units having equal status and uniform relationship with the center, except where for any strategic, security or other compelling reason it is not practicable to integrate any small area with the territories of the full-fledged units. Then the presence of social institutions is yet another prerequisite for having a federal setup. So there should be similarity of social institutions generally. It is true that the desire for union can be created in spite of dissimilarities of social institutions as happened in United States and Canada, but such differences, says Weers, do not have a government more difficult, and there is a limit to the degree of dissimilarity which can be permitted. So the capacity to work together cannot survive in extreme differences and divergences. So the capacity of state to form and work as a federal unit, he added, depends upon some agreements to differ but not to differ too much. So a stable federalism demands a considerable capacity to agree in practice upon what is matter for unity and what is matter for diversity. So it's accordingly essential that the nature of diversity and the unity be such that the practice views can be, or the practical views can be adjusted and the differences reconciled. So there should be a common meeting ground upon the national policy as well as upon the local liberties of the constituent units. Now the size of those federating units also plays a very important role in its one of the prerequisites. The capacity of the state to work as a federal union is also influenced by the size. It is desirable that there should be, as far as possible, equality among the component parts of the federation in their size and population. Now, if there are wide differences in size and population, as in India, where the states of Uttar Pradesh, Madhya Pradesh, Bihar, Rajasthan are in no comparison with small states of Punjab, Haryana, Sikkim, Goa, and many other, the federating areas and federating states are not equal partners in a union. So unions and units large in size and population and more powerful in resources than others may be too proud and domineering for smaller ones. So they may even overrule the others and bend the will of the central government to themselves. So the idea of dominance by one, it creates suspicion and lack of confidence in others. And the confidence is the essence of the will to federate and the capacity to work in the federal government. So the essential prerequisite of a federation, says Mill, is that there should not be any one state so much powerful than that of the others that it creates a kind of a competition between them. If there be such a one, the only one, it will insist on being master of the joint deliberations. If there are two, they will be irresistible when they agree, and when they differ, everything will be decided by a struggle of ascendancy between the rivals. Finally, the federating states, they must possess adequate economic resources to support both an independent national government and the independent regional governments. A federal government establishes a new national government, it must be given sufficient independent economic resources if it is to perform its duties efficiently and effectively. Likewise, it is also imperative that the regional governments, they must also be left with the adequate economic resources to run their administration and perform the functions assigned to them satisfactorily without being dependent on the doles of the national government. Now, if resources left are not sufficient to support an independent regional government, then no matter how states desire a federal union, no matter whether they have a federal constitution which is drawn up, in practice the federal government will not be possible, because soon the regional governments will be unable to perform their functions, or they will be able to perform their functions only with the price of financial dependence upon the general government, that is at the price of their financial unification. So one of the reasons for which the leaders of South Africa rejected the federal union was that the country would be unduly taxed if they were required to support both a central government as well as independent regional governments. So federation is an expensive mechanism, and it should be adopted only when the constituent units can pay the price of retaining their separate identity and independence of action in the sphere that is assigned to them. Now we move on to the essentials, from prerequisites to essentials of a federation or federating unit. Now the very first is a written constitution. Now, for a federal government, the constitution must necessarily, almost necessarily, be a written constitution, which defines very clearly the relation between the central government and the regional governments, marks out the sphere of each, and is paramount over the constitution of the regional governments. Now, if each component part of the union has its own separate constitution, to base an agreement of this kind, right dicey, upon understanding or convention would be certain to generate misunderstanding and disagreements. So, such arrangements cannot be left for conventions to decide. It must be written in black and blue, that is on a paper, that is constitution. So, the article of the treaty, or in other words of the constitution, must therefore be reduced to writing. The constitution must be a written document, for it is the charter of rights and duties of the federal and state authorities. Now, the expert, one of the experts on constitution, Weers, says that if the government is to be federal, its constitution must be supreme. By the supremacy of constitution, he means that the terms of the agreement which establishes the general and regional governments and which distributes power between them must be binding upon the general and regional governments. Now, this is a logical necessity from the definition of the federal government itself. Now, if the central government and the regional governments are to be coordinates with each other, neither must be in a position to override the provisions of the constitution regarding the powers and status which each is to enjoy. So, definiteness of constitutional status and power stimulates the will to federate and creates confidence in confederating units that the sanctity of their sphere of jurisdiction will be maintained, and in case of invasion of their rights and encroachment on their constituent functions, there are constitutional remedies to seek judicial redress. So, the power of judicial review is inherent in a federal polity. Now, the second essential is that of a rigid constitution. That is, the natural conclusion of a supremacy of constitution is being a written document is that it should not be alterable either by the central legislature or by state legislature under their ordinary lawmaking procedure. So, the law of the constitution, says Dicey, must either be immutable or else capable of being changed only by some authority above and beyond the ordinary legislative bodies, whether federal or state legislature existing under the constitution. Now, it is essential for federal government, says Weers, the power of amending the constitution, so far at least as concerns those provisions of the constitution which regulate the status and the powers of general and regional governments, should not be confined exclusively either to the general government or to the regional government. If it is confined exclusively to one set of government, it does not give equality of status to both, and if it is also probable that the one which possesses that power may in an ordinary process of legislation make an invasion on the powers and jurisdiction of the other. So, rigidity is something which is expected. So, we talk about United States, there we find that it does not matter legally whether the power of amending the constitution is placed where it is placed, whether the states or the center. There can be no doubt, as we have suggested, that practically it's wise to associate both the general governments and the regional, either their governments of their people, in the process of amending the constitution. In United States, we find the amendments to the constitution may be proposed by a majority of two-thirds of both the houses of Congress, or by a convention summoned by Congress on the application of the legislatures of two-thirds of states. So, the proposed amendments become effective when ratified by the legislatures of three-fourths of the states, or by a convention in three-fourths of the states, according to the one or the other method of ratification proposed by Congress. So, no alteration in the boundaries of the existing states, the Constitution further prescribes, can be made without the consent of the legislature of the states concerned as well as of Congress. In the case of Australia, we see the Constitution can be amended on a proposal by an absolute majority of two houses of Parliament of the Commonwealth, or in certain circumstances, one house, and its ratification at a referendum of the people. Now, if this referendum majority of all the electorates voted the approval of the proposed law, and if in a majority of states a majority of electorate voting also approve of the proposed amendment, then it is submitted for a royal assent and the changes so made. So it is further provided that amendments relating to changes in the representation of the states in either House of Parliament or any alterations in the boundaries of the states must be approved by a majority of the electorates in that state concerned. In the case of Canada, we find that the power of amending the North American Act 1967, it rested with the Parliament of Britain. No authority in Canada had power till 1982 to alter the division of powers between the Dominion and the provincial governments. Now, the convention as it existed was that the Parliament in Britain would amend the Canadian Constitution on a request from Canada, but there was no settled convention whether the request for the amendment should come from the Dominion Parliament or the government alone, or from the provincial legislatures and the governments alone, or through some sort of cooperation between the two. With alteration of the Canadian Constitution in 1982, the Constitution can now be amended by a resolution of the Senate and the House of Commons of the federal government and 7 provinces representing 50% of population of the country. The amending formula gives for the first time a legal role to the provinces in making constitutional changes. And similarly, in Indian Constitution, we find that the union of where it came into existence, the Indian Constitution provides 3 different methods of amending. In some part of Constitution, that is, some part of Constitution can be amended by a simple majority in both the Houses of Parliament. For example, new states may be created or existing states constituting the upper chambers created or abolished in the states, and then certain specified subjects as amendments affecting the method of electing the president, extent of executive and the legislative powers of the union and the states, and the provisions regarding the Supreme Court, the representation of states in Parliament, and the method of amending the Constitution. It requires a majority of the total membership in each House of Parliament and a majority of 2/3 of members present and voting in each House of Parliament, and a ratification by legislatures of 1/2 of the states. And finally, the remaining provisions, there must be a majority of total membership in each House of the Parliament and a majority of not less than 2/3 of the members present and voting in each House of Parliament. So it follows that if the Constitution of a country is to be a living document, responsive to the needs of the people and the time, it must contain a provision for amending it, and even federal Constitution contains such a provision. But the process of amending the Constitution, which provides a federal polity, must be distinct, involving a different procedure from the ordinary lawmaking procedures. So, and the all interest and parties in the federation should participate therein, and the method of amending a federal constitution is therefore more difficult and complex than amending a unitary constitution, and that is the reason why it is practically a rigid constitution. And the third is the requirement of having a federal court. So, presence of federal court is another necessity which is responsible for formation of a federalism or federal country. So, the federal court, it decides the disputes between the jurisdiction arising from the central government and the regional governments, or the balance between the two, between one regional government and another, and it keeps different governments within their limits so that none can encroach upon the sphere of the jurisdiction of the other. So, if the federal principle is really to work, it is necessary there should be an empire of independent nature, both central and regional governments, which should be vigilant to its requirement, its rights, and approach the court in case of any kind of abrogation. Now, a happy balancing between the two forces is essential and as an essence of federalism, and there can be no other authority than an independent, impartial judiciary which can act as a guardian of the Constitution and thereby protect the constitutional distribution of powers. So, the need for the federal judiciary has been expressed by Mill in his words, and often quoted or paraphrased, that when he says it is evidently necessary not only that the constitutional limits of the authority of each, the central and regional governments alike, should be precisely and clearly defined, but the power of deciding between them in any case of dispute should not reside in either of the government and in any functionaries subject to it, but in an empire independent of both. So, there must be a Supreme Court of Justice and a system of coordination and coordinate courts in every state of union before whom such questions can be carried, and whose judgment on them in the last stage or is an appeal is final. So, Sedgwick says that the more stability is given to the Constitution by making the process of changing it becoming difficult, and greater becomes the importance of this judicial function of interpreting its clauses. So every federal constitution accordingly provides for an independent and impartial judiciary entrusted with the work of deciding disputes between the several governments, to uphold the supremacy of constitution and to interpret it. But while interpreting, the judges also expound the constitution by explaining its implications, as happened in the case of the doctrine of implied powers propounded by the Supreme Court of the United States. The Supreme Court of the United States derived, saying that the Supreme Court says that the authority is derived directly from the Constitution, and the method of appointment of the judges and their removal and the pay and allowances they are entitled to all are prescribed by the Constitution, ensuring the independence and impartiality of the judiciary. Now, with that, I come to the end of my presentation of today on prerequisites and essentials of federal government. Thank you.